This is Bloomberg Law with June Grasso from Bloomberg Radio.
Today, the Supreme Court unanimously preserved access to the abortion pill that was used in nearly two-thirds of all abortions in the country last year. In the court's first abortion decision since conservative justices overturned Roe v. Wade 2 years ago, the justices reversed a federal appeals court ruling that would have barred mail-order prescriptions for mifepristone across the country. The ruling was based on a procedural issue called standing, finding that challengers in the case, anti-abortion doctors and medical groups, failed to show they were injured by the FDA's approval of the medication. It was the issue we heard voiced by justices across the ideological spectrum during oral arguments, from liberal Ketanji Brown Jackson to conservative Brett Kavanaugh, who wrote today's opinion.
I mean, it makes perfect sense for the individual doctors to seek an exemption. But as I understand it, they already have that. And so what they're asking for here is that in order to prevent them from possibly ever having to do these kinds of procedures, everyone else should be prevented from getting access to this medication.
Just to confirm on the standing issue, under federal law, no doctors can be forced against their consciences to perform or assist in an abortion, correct?
But the court didn't even address the FDA's decision to loosen the restrictions on mifepristone. So this decision doesn't mean that the drug is safe from future legal attacks. Joining me is an expert in reproductive health care rights, Mary Ziegler, a professor at UC Davis Law School. Mary, did this unanimous decision, come as any surprise after the oral arguments?
I mean, it was a little bit of a surprise that it was unanimous, but I think after oral argument, it was pretty clear that the plaintiffs were in trouble here on standing grounds, and their standing arguments were really weak, from the outset. So in that sense, it wasn't a surprise.
And tell us how the court came to its decision on standing.
Well, the court had three different grounds for deciding the plaintiffs didn't have standing. The plaintiffs argued that they had standing because they could face conscience-based injuries if patients had complications from mifepristone and ended up in the emergency room where they were practicing. They argued that they would suffer economic harms potentially if forced to treat patients. And finally, they argued that their group, their association, suffered harms because it was forced to divert resources that could have been used for other pro-life or anti-abortion work to oppose mifepristone. And the Supreme Court rejected all three of those claims. On the conscience point, the justices said essentially there are lots of federal laws to protect conscience, so there's no real threat of injury here. On the claims about economic harm, the court said this is just way, way too broad, almost to the point of ridiculousness. They said if this was true, as a theory of standing, firefighters could sue to object to relaxed building codes, and teachers in border states could sue to challenge immigration policies. This would be a Pandora's box. And finally, on associational standing, right, the idea that the association was diverting resources, the court emphasized that this would be essentially allowing organizations to manufacture standing by spending money to gather information and advocate against inaction. So all three of those standing claims failed, but again, they were specific to these parties, so it doesn't mean that these claims will necessarily go away forever, just that these plaintiffs were unable to bring them.
Yeah, in fact, on the last page of the opinion, Justice Kavanaugh wrote, quote, "It is not clear that no one else would have standing to challenge the FDA's relaxed regulation of mifepristone. And the Texas judge below has allowed the states of Idaho, Kansas, and Missouri to join the case at the district court level to help press the same claims against the FDA. So that's still pending."
Yes, so there are these other plaintiffs in the district court who had initially tried to intervene in the Supreme Court proceedings and were turned away, but who are proceeding through the lower courts, arguing that they have the standing that these plaintiffs lacked. And it's worth emphasizing, too, that that isn't necessarily the end of it either. There are some local counties and cities in what's called the Sanctuary City for the Unborn movement that have been mulling bringing suits on the same basis and asserting they have standing. So I think we're seeing already some plaintiffs in the lower court trying to say they can bring these claims, and they might not be the only ones.
And the Supreme Court can almost get pushed to hear these cases. For example, in this case, you have the most conservative circuit in the country, the Fifth Circuit, pushing the legal envelope and finding that these plaintiffs have standing to sue. And then the Supreme Court has to respond and push back.
Mm-hmm. Exactly, right. And it doesn't necessarily mean that those plaintiffs will succeed either, right? I mean, they might not have standing either. But I think all we know after today is that the Supreme Court is kicking the can down the road. They haven't resolved many of these claims permanently.
And the court stopped short, way short, of affirming the FDA's decisions to expand access to mifepristone. I mean, they didn't consider the merits at all in the opinion.
Right. I mean, if anything, the court seems sympathetic to the idea that people have conscience-based objections to abortion. The court seemed to be sympathetic to those. And the court didn't at all affirm the logic of the FDA's decision-making, didn't say anything one way or another about the plaintiff's theory that the Comstock Act operated as a de facto ban on abortion. So we got really no insight, especially no insight that would be reassuring to the Biden administration about what the court thinks about those things.
Justice Kavanaugh wrote, "The plaintiffs have sincere legal, moral, ideological, and policy objections to elective abortion and to the FDA's relaxed regulation of mifepristone." That language is a little troubling, isn't it?
I agree. I mean, and I think it signals that we haven't seen the end of this by a long shot.
And there's some irony in the fact that Kavanaugh wrote a concurring opinion in the Dobbs case, which overturned the constitutional right to abortion. And he said basically the abortion issue is now up to the states. We're done with it.
Yeah, I mean, I don't think anybody paying attention really believed that, but it's ironic, of course, that the court has two abortion decisions in one term. I mean, this isn't even the last we've heard from this particular term on abortion, which is extraordinary. So this is not, not even the end of what we're hearing from the justices right now, much less, for the longer term.
Mary, does this mean that women in every state can get mifepristone, or is it still illegal in states that have bans on abortion?
It's still illegal. This ruling doesn't change the status quo. So if a state has prohibited mifepristone, it's still prohibited in the state. If a state has access to mifepristone or provides that access, the drug is still available. So it isn't undermining any state law one way or another.
You mentioned the second abortion case that's yet to be decided over Idaho's strict abortion ban. Tell us about that.
That case involves emergency access to abortion. The Biden administration has argued that a federal law called the Emergency Medical Treatment and Labor Act trumps state bans when those bans wouldn't allow access to abortion for certain medical emergencies that the federal law would require. Idaho, the state the Biden administration took to court, has responded that the EMTALA does nothing of the sort, and that the question is either left to the states or even that EMTALA offers some protection for the unborn child, as Idaho puts it, pointing to language in the statute. So that ruling remains to be seen and could have pretty important effects.
After the oral arguments in the mifepristone case, it seemed pretty clear what the decision would be. Can you glean anything from the oral arguments in the Idaho case?
I mean, it seemed as if the court was likely to side with Idaho, although the oral argument was a little bit all over the place. So it's not entirely clear that that's going to be true. And if it is true, it's not entirely clear on what basis they're going to side with Idaho. So I think we're expecting a win for Idaho, but on what basis or, how sweeping a win, I think remains to be seen.
And tell us a little about the lawyers for the anti-abortion doctors and medical groups here. They're from the conservative Christian legal advocacy group, Alliance Defending Freedom, that's been behind a lot of Supreme Court decisions.
And so the Alliance, the plaintiffs here are probably less important than the attorneys representing them, who are the Alliance Defending Freedom. That's a group that has really been dominating in some ways the landscape of Supreme Court abortion litigation since the Supreme Court overturned Roe v. Wade. So this is part of a much longer game for them. They have lots of other cases and strategies in the pipeline, including challenges involving abortion pills. So we're going to see, I think, much more where this came from them.
We've talked before about the fetal personhood movement, which is an effort to give fetuses the same rights as a person, including the right to life. But you mentioned the Sanctuary City for the Unborn movement. What's that about?
This movement has created ordinances in a variety of cities. These were the model for Texas's SB 8, which, as you may know, is the bounty bill that passed in Texas. It's now spreading ordinances based on the Comstock Act. It's spreading ordinances designed to limit interstate travel for abortion. The man behind it, Jonathan Mitchell, and his colleague, Mark Lee Dixon, have had a lot of influence on anti-abortion strategy as well. So I think they're also looking at a potential way into helping with this kind of challenge.
Anti-abortion activists are using different kinds of strategies to try to prevent abortions. And we see laws passed in states that target abortion in different ways. What's the most concerning?
That's absolutely right? So there's very much a kind of like throw it at the wall and see what sticks that's going on here. Many of the strategies you mentioned, June, involve abortion pills. So some of them involve making it easier to survey and track who's using abortion pills, in part because states where abortion is legal have been passing shield laws, some of which allow physicians to mail pills into banned states. So some states are looking for tools to track and ultimately prosecute that usage. We're seeing efforts, again, to limit travel, often called abortion trafficking ordinances that criminalize assisting people traveling for abortion. We've seen efforts to even do strange things like label mifepristone a threat to the environment and to the groundwater. They're targeting the Environmental Protection Agency. And that's just the tip of the iceberg. Probably the most salient rely on the strategy that Donald Trump will, win the 2024 election and that his Justice Department will be able to enforce the Comstock Act as a ban on abortion, and that would, of course, override not just state laws, but even ballot initiatives that voters are deciding for themselves when it comes to protecting abortion rights. So there are a lot of strategies in play here, and this case is just a small piece of a much bigger puzzle.
Finally, Mary, some are breathing a sigh of relief because the Supreme Court has allowed access to mifepristone. But this doesn't mean that mifepristone is safe from legal attack at the Supreme Court and elsewhere.
No, not at all. The Supreme Court is just saying that these particular plaintiffs don't have standing. This case, these claims aren't even going away. That's the most basic point. But, it's certainly not true that abortion is safe and that other attacks on abortion pills or abortion aren't ongoing.
Thank you so much, Mary. I always appreciate your in-depth analysis in this area. That's Professor Mary Ziegler of UC Davis Law School. Coming up next, the justices reveal the extra money they earned last year in addition to their $274,000 salary. Guess who's on the top of the list getting a nearly $900,000 book advance? And what about those $4,000 tickets to a Beyoncé concert? And the justice, who like a bad student in school, asked for an extension. The justices will be issuing decisions again tomorrow. Some of the most controversial cases of the term are still in front of them, those involving Donald Trump and presidential immunity, guns, social media, homelessness, the wealth tax, and the power of agencies to fight things like climate change. Of the 61 cases the court heard this term, 26 decisions are still outstanding. But the justices do have behind them the revelations about their finances. Well, all the justices except Samuel Alito, who got the extension he requests every year, for a reason only he knows. And surprise, it was the newest justice, Ketanji Brown Jackson, who topped the list with an $893,000 advance for her yet-to-be-published memoir, followed by Justice Brett Kavanaugh. Bloomberg News Supreme Court reporter Greg Stohr has looked at all the numbers. Clarence Thomas suddenly remembered about some luxury trips back in 2019?
These are the trips that he took with Harlan Crow that were the subject of the first big story about this subject about a year ago from ProPublica, including this cruise that he took on Harlan Crow's yacht in Indonesia. Now, Justice Thomas's disclosure, this was a trip in 2019. In his new disclosure. He mentioned at the end that in his original 2019 report, he had inadvertently admitted a couple items. And he disclosed not the cruise itself, but he disclosed the food and lodging he got for one night in a hotel in Bali. He also disclosed food and lodging in California and a separate trip at this retreat known as the Bohemian Grove. So he didn't disclose everything about it, but it was at least an acknowledgement that these trips seem to have happened.
But he may now have more trips to account for. According to documents released by Senate Democrats just today, Thomas failed to disclose at least 3 more private jet trips across the U.S. paid for by GOP megadonor Harlan Crow. In any event, these trips represent an enormous amount of money.
Yeah, an enormous amount. There's a watchdog group known as Fix the Court that did some very rough calculations and came to the conclusion that Justice Thomas received more than $4 million overall in gifts since 1991, including these trips.
The most interesting gift to me was the nearly $4,000 in Beyoncé tickets that Justice Jackson got, and she topped the list.
Yeah, she did top the list. That was a bit of an eye-opener. $3,712 for 4 concert tickets.
I know I spend that every time I go to a concert.
Yeah, exactly. She also reported 2 gifts of artwork for her chambers at $12,500. Yeah, that was certainly the one that captured a lot of attention. No suggestion she did anything wrong there, but she made a decision that this is the kind of gift she's comfortable accepting and then disclosing. And, it's not something that other justices necessarily do.
Thomas also disclosed receiving photo albums worth $2,000. It just seems to me like it's a bad look for justices to be accepting these kinds of gifts. Is there any rule or ethical consideration that they have to make, or are they just allowed to take anything they want?
Well, they do have to disclose them. That's sort of the one rule about that. And if, Beyonce were involved in a Supreme Court case, you would expect Justice Jackson would probably recuse. But no, that is very much the issue that people are talking about. And, is it a bad look to be doing any of this stuff? And the other element I would toss into the mix is that, the justices collectively collected about $1.5 million in book income last year, including a big chunk of that was Justice Jackson for a book that has yet to be published. And we just learned in the last few days that Justice Kavanaugh is coming out with a book, and he reported 6 digits in income from that book. So, they are picking up extra income in ways that, certainly are eye-opening and do sort of raise questions about, whether that is the kind of, as you put it, look we want from a Supreme Court justice.
I mean, a lot of judges give up lucrative private practices to become a judge, to do public service. And here you have the majority of justices on the highest court in the land making book deals, etc., and making the kind of money that separates them from the vast majority of Americans. It may not be unethical, but it just strikes me as, what's wrong with this picture? But I noticed that Justice Kagan never seems to be involved with any of these extra income things, books or anything else. Was there anything on her financial revelations that was noteworthy?
No, she's really one of the ones who has not written a book, is not accepting unusual gifts, and has largely steered clear of any of these ethical issues. She is, I think fair to say, a good deal more cautious and careful, along with the Chief Justice. He's the other one I would sort of put in that mix as people who are very careful about what they accept and the appearance they give off when they, make appearances and the like. They make different decisions, and of course, one of the issues here is that all these decisions are up to individual justices. Justice Kagan believes that justice should operate a certain way, and she's allowed to do that. And Justice Thomas believes something very different, and there aren't really any constraints on him.
There was an issue about the Chief Justice's wife, right? She's a legal recruiter?
Yeah, she left her law practice to become a legal recruiter, and there have been some stories about her work there, but I think when you talk to judicial ethics experts, that's one where, in general, they tend to say first of all, a spouse does have a right to his or her career, and that is so separate from the work that the Chief Justice does. The idea that somehow it might influence his decision making that she is involved in hooking up a lawyer and a law firm. That's not high on the list of ethical issues we should be worried about.
And so Justice Alito received a 90-day extension to file his report, and he's done that before? I mean, it seems odd since he's filed his taxes.
Yeah, he does it every year. We never get a real explanation for it. No other active justice does it as a matter of course. Last year, Justice Thomas got an extension, but that had more of an explanation to it because he was dealing with a lot of these new revelations and some changing guidance about how to file reports. So that made a little more sense, and Justice Thomas did file his report on time this year. Yeah, I don't have an explanation for why he does that. We will certainly look at his filing when it comes in.
But it puts more emphasis on it if you're the only one, at a certain time coming out with it.
Unless you do it at a time when all the people who be covering about it are on vacation because it's the middle of the summer.
You make a great point, Greg. You know your Supreme Court justices very well. Thanks so much. That's Bloomberg News Supreme Court reporter Greg Stohr. And yesterday, Senate Republicans successfully blocked a bill that would have required the Supreme Court to adopt a code of conduct and would have created a mechanism to enforce it. Senate Judiciary Chair Dick Durbin criticized Chief Justice John Roberts on the Senate floor for not doing enough to enforce ethical standards on the Supreme Court. Coming up next on the Bloomberg Law Show, so where can you go in Manhattan if you want to see some famous politicians, billionaire businessmen, top lawyers, and lots of journalists? We'll tell you coming up next. I'm June Grasso, and you're listening to Bloomberg. So where can you go in Manhattan if you want to see some famous politicians, billionaire businessmen, and top lawyers? Go downtown to Lower Manhattan, where courthouses abound, and where in the last few weeks, like a planetary alignment of the justice system, politicians and Wall Street figures have been crossing paths at simultaneous trials of former President Donald Trump, Senator Bob Menendez, Christian billionaire Bill Hwang, and fugitive Chinese tycoon Guo Wangui. Joining me is someone who has experienced this firsthand, Bloomberg legal reporter Ava Benny-Morrison. How big is the area downtown where the federal courthouse and the Manhattan state courthouses sit?
It's quite a condensed little area down there. You have the federal courthouse, which is on Pearl Street, and then across the road from that you have the New York State Supreme Courthouse. And then there are a couple of other federal courthouses, state courthouses in the streets around that. So it's all very walkable. They're all very close to each other.
Tell us about the 4 trials that until last week were going on in what you called a planetary alignment of the justice system.
Yes, it certainly has been very busy down there. In the state courthouse, New York State Supreme, we had former President Donald Trump on trial in the hush money case. That was until he was convicted last week. And then in the federal courthouse, we have 3 trials going on at the same time, just a few floors apart. Firstly, we've got Bill Hwang, who was the founder of the immensely successful family office Archegos Capital Management. Archegos collapsed in 2021, and that reverberated around Wall Street, led to massive losses for a number of big banks, and almost wiped out Bill Hwang's $36 billion personal fortune. He's accused of fraud, market manipulation, and racketeering. We've also got the trial of Senator Bob Menendez. He is accused of accepting bribes while he was in office. That trial has been going on for a couple of weeks now, and we've had some interesting witnesses, cooperating witnesses who are testifying against Menendez. And then lastly, we have Chinese tycoon Miles Guo. Miles Guo has been living in New York for a few years. He's a close associate of Steve Bannon. He's also close with hedge fund manager Kyle Bass. He's accused of fraud and swindling up to $1 billion out of investors. So it's all happening there at once.
Can I assume that while the hush money trial was going on, that all the attention and the crowds were around that courthouse?
Yes, they certainly were. But because of how close the courthouses were, some of those crowds were spread out. For example, every afternoon before about 4 p.m., there was a small group of Trump supporters that would gather outside the federal courthouse, which is across the road from where Trump was obviously on trial, and they would turn out with Trump flags, Make America Great Again hats, horns, whistles, and they'd wait for him to drive past in his convoy when he would leave court each day. And he would slowly roll past. He wouldn't wind down the window, but he would give them a wave through the very dark windows. And they'd get very excited about that, but they'd pack up and return the next day.
Wall Street is really watching the Wong trial, and a lot of attention is on Menendez too, but Wong seemed to have benefited from the concentration on Trump.
Yes, exactly. Especially in the finance world and on Wall Street, everyone knows who Bill Hwang is, and there is a lot of interest, as you said, in his trial. Yet, because of all the other high-profile trials going on, we've got Menendez, Trump, every time Bill Hwang walks out of the courthouse, he goes largely unnoticed by the people that are standing outside and the Trump supporters. In contrast, Menendez, when he walks out of the courthouse by himself, he's often heckled by some of those supporters who yell things at him, and the U.S. Marshals have to clear a path for him so he can get into a waiting car. So it's been interesting that someone like Bill Hwang, who had such a massive impact on the finance world only a couple of years ago, can sort of go in and out of the courthouse largely unnoticed. So I think he's definitely benefited from having his trial underway in the same building as someone a bit more high profile like Bob Menendez.
Do these famous defendants ever run into each other?
So even though these men have been on trial in separate trials, separate courtrooms, there's often some moments where they cross paths, especially in the morning. Everyone who doesn't have a pass to get into the federal courthouse has to line up in security, and that can be a wildly different mix of people. You've got witnesses who are testifying, you've got people lining up for naturalization ceremonies, you've got defendants, out-of-town lawyers. One morning we saw Bill Hwang waiting in the marble lobby foyer and looking at some of the court sketch artist pieces that were hanging on the wall that had captured moments in other high-profile trials that had happened inside that courthouse. Behind him through the glass, you could see Senator Menendez waiting in the security line, and just a few people ahead of him was Scott Becker. Scott Becker used to work for Bill Hwang at Archegos, and he was preparing to testify against Hwang later that day. So the courthouse has certainly been a melting pot of very interesting characters and cases.
Now, does Wong or Menendez have an entourage?
Hwang certainly has an entourage. He has had at least a dozen people turn up at his court case every single day. They take up 2 or 3 of the benches in the public gallery, and they'll often join him for lunch inside the courtroom cafeteria. So he's definitely got his fair share of loyal supporters around him every day. Menendez has been more of a lone figure. I've only ever seen him with his lawyers waiting for the elevator or outside the courtroom. When he has walked out of the courthouse, he's often been by himself. Sometimes he stops and gives interviews to some of the Spanish-speaking media who have been gathered outside, but largely he's coming and going from the courthouse on his own.
The courthouses there are near Chinatown and Little Italy. Do they head off there for lunch?
Not that I've seen. In the past, there have been defendants who have been on trial who have chosen to leave the courthouse during the lunch break and go and find some dumplings in Chinatown around the corner. But in this case, I've almost seen Hwang in the court cafeteria every day, sitting down with his wife and some of his employees from his nonprofit, the Grace and Mercy Foundation. His co-defendant, Patrick Halligan, I've seen him a couple of times eating lunch outside in the patio, which I've got to say has quite beautiful views of the Brooklyn Bridge. So it's a nice place to sit, especially as the weather gets warmer. Menendez, though, hasn't been seen around the cafeteria, so I don't know where he's bunkering down to have lunch each day.
Yeah, court cafeterias often have, prosecutors, defense attorneys, judges, defendants, all in this one place with their trays. It's really unusual, the feel of it, because they're normally on opposite sides. It can seem sort of surreal sometimes.
Absolutely. And jurors aren't allowed to go to that cafeteria because there are defendants, witnesses, prosecutors, defense lawyers coming and going constantly. But it certainly has been a buzz of activity. There are people lining up for sandwiches. One day you can be standing next to a federal court judge. The next day you're standing next to the federal prosecutor who's presenting the government's case in the massive racketeering trial upstairs. And then you see a defendant sitting down with his wife next to the court security officer who's in charge of ensuring everyone's behaving themselves in his courtroom. So, they're human beings. They need to eat at some point. So it's interesting just to see the mix of people that end up sitting next to each other, snacking on chicken salad or a slice of pizza over lunch.
And these trials, the Menendez trial, the Huang trial, and the Guo trial, are they expected to take much longer? Because they have been going on for quite a while.
They have been going on for a while, and they still have a bit to go. I checked in on the Guo trial this morning, and I think that the prosecution's only about halfway through its case. In the Huang trial, the judge estimated that it may well spill into July at this point. And in the Menendez case, the prosecution is still presenting its evidence. So we've still got a few weeks to go in each of these trials. It's been a real juggle, I think, for the reporters covering it, trying to run between each courtroom.
And former President Trump complained about, the courthouse, the Manhattan Criminal Court. I mean, the federal courthouse is much nicer than the state courthouses.
Yes, it is. The federal courthouse is quite grand. It's got a big open marble lobby. The courtrooms have great acoustics, which is very important when you're trying to hear what everyone's saying. Beautiful views over the city and over the Hudson River. There's a great big press room there that we all work out of. So it is a lot easier to work out of there than it is, I think, in the state court, which is a lot older. A lot of the reporters who were covering the Trump trial had to line up for hours each day to get a spot in an overflow room. So there have been, totally different experiences covering trials in each of those courthouses.
Well, it's a really interesting time to be covering trials in downtown Manhattan.
It's really buzzy. There's prosecutors everywhere, lawyers everywhere. You just run into people at the most random of places. Everyone's sort of saying, what are you going to, or what are you covering? Oh, this person's up in this trial, or quick, let's get down to this. So it's a really fun time to be there.
Okay, Ava, you'll have to report back to us as the trials wind down. Thanks so much. That's Bloomberg legal reporter Ava Benny-Morrison. And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.